Thank you, Madam Chair, and I thank the committee for allowing me to waive on for the purpose of this hearing. Good afternoon, Dr. Hicks. Madam Chair, first I ask for unanimous consent to enter 2 items into the record. I think committee staff should have them. One is a 1952 article regarding military opposition to desegregation of the armed forces, and the other is a 1972 report from President Nixon's task force on racial disparities in the military.
Without objection, so ordered.
Thank you, Dr. Hicks. Under the Vanessa Guillen Act that's been introduced, and let me preface by saying, I've served as a commander in the Army at 2 levels. I served as a JAG. I've advised commanders with court-martial convening authority. I understand the importance of the punitive articles and the procedures, non-judicial punishment in the Uniform Code of Military Justice as an important tool to maintain good order and discipline. In this act, the commanders retain the authority to issue non-judicial punishment. They retain authority over military-specific crimes, dereliction of duty, AWOL, malingering, insubordination, the list goes on. And they also retain the ability to refer charges to special court-martial, for example, simple assault, right? The dining facility fight. Can you explain the department's thinking why those are not sufficient tools to maintain good order and discipline for a commander?
Congressman Brown, we have not looked, as I said, we have not looked at this issue set. We looked very broadly and then very deeply on sexual assault and sexual harassment. We have not taken on, and there aren't studies other than the one I mentioned that the department or department-related bodies have done looking at what it would take or what the implications would be. What I will tell you is our focus right now, and as I sit before you right now, is making sure we get it right on the sexual harassment, sexual assault, and related crimes.
Then let me ask you a follow-up on that.
Please do.
And I appreciate that. So the DOD, the department's proposal for reform, only partially implements the recommendations of the IRC. Notably, and correct me if I'm wrong, notably the department only establishes one of the recommended 3 special victims categories. I think one of them is, which the department accepts, are the specified offenses, but does not accept the trait of victim, category number 2, and category number 3 is intent of offender. Now, you have acknowledged, the department has acknowledged the complexity of these cases, the need to follow best practices, special victims units, which we see in DA's offices around the country. And they do that so that they can take on all 3 categories as recommended by the IRC. The IRC also recommended that there be judge order military protective orders. So I guess my question is, the department, after decades, has resisted change. I think a 60-day or 90-day review by the IRC, very comprehensive, very capable and knowledgeable people. They've come back with robust recommendations to address sexual assault. Why is the department not accepting their recommendations in their entirety?
The department is looking ahead not just at the legal piece of this, but at the change, implementation, and management side of it. And in doing that and weighing the advice inside the department, outside experts like the IRC, the approach really is this balance of how do we implement change that has real effect quickly, meaningfully, and that can withstand challenge. I'm sure you know the UCMJ changes. The UCMJ are frequently challenged in court. We saw the Australians, when they moved to an outside system, that actually was thrown out by the Australian Supreme Court, and so they had to restart. So
but we also know that
let
me just say, in this country, the courts have deferred tremendously to both the executive branch and Congress in implementing the rules that regulate the armed forces. I mean, they really have. So I'm just really concerned because, for example, in that category 2, trait of victim, you could have a scenario where you have intimate partners and where one partner is stealing from the other partner as a form of abuse. And I'm not sure if just following Category 1 specified offenses that would qualify as an offense that would be now under this new system. Yeah.
Congressman, I completely understand. The same thing will happen if you make a one-year differentiation. So
well, the reason why I beg to differ, again, going to best practices, and if you didn't just indulge me, Madam Chair, you know, I do believe in best practices. And when you look at the best practices in U.S. attorneys' offices and in DAs, they have felony divisions and they have misdemeanor divisions. And there is overlap in those divisions. Within felony divisions, you have special victims units. And those special victims units are much more comprehensive than what the department is willing to accept from the IRC. You took members with tremendous amount of experience, created an IRC, yet are coming back and only embracing a much narrow subset of what they're recommending. And that's on the special victims piece, not the felony misdemeanor piece. So that's my concern. I've been hearing a lot about best practices, but yet I'm not really hearing the adoption of best practices. And if I can just complete on this point, Madam Chair, I've heard a lot about solving the problem. For 10 years, we've brought this problem. Commanders have it, commanders have it, commanders have it. Finally, after a 90-day review, commanders didn't have it, we recognize. And why? It really comes down to a data set that soldiers, sailors, airmen, Marines, and Guardians don't trust commanders. That's the primary data set here, the lack of trust, and that's why we're taking it away from the commanders. I put into the record a 1972 study. What they found was a lack of trust. Black and brown service members in commanders. This issue has been around for a long time. The problem can be simplified. It's not a simple problem. It's an under-prosecution of sexual assault and an over-prosecution of black and brown people. We know the problem. There's a lack of trust between black and brown and commanders in the military justice system, and there's an opportunity to address that. Just like we believe removing from the commanders referral of charges, sexual assaults, to solve this lack of trust problem, we can do the same thing with a broader set of offenses, because I heard someone from the department recently say, well, the sexual assault's it's a pressing problem right now, and nobody will disagree with that. But the over-prosecution of black and brown people in the military justice system, and when capital punishment was issued in the military justice system, over-representation of black men being prosecuted and found guilty of capital punishment in the military. That's a pressing problem. And yet we have an opportunity here to begin addressing it. And what I haven't heard from the department is, well, we don't want to do the sweeping reform, but can you at least give us some more tools? And all I'm hearing is, we'll fix it. And that's what we've heard for 10 years for sexual assault. Thank you, Madam Chair. I yield back.